Hello everyone, welcome to day 56 of Polity Daily Drill. Let's begin. First question, with reference to fundamental duties under the Indian Constitution, consider the following statements. Number 1, it has no direct enforcement by courts. Absolutely correct. Fundamental duties are not enforceable by courts. Number 2, some fundamental duties are correlative with legal duties. Yes, of course. In fact, fundamental duties were added in 1976 via the 42nd Amendment Act. However, even before these duties were incorporated, we already had laws in the country which made it illegal to perform certain activities. For example, we have a law called the Prevention of Insults to National Honor Act of 1971, which prevents disrespect to the Constitution of India, to the national flag and the national anthem, which is similar to the duty that we have, that it shall be the duty of every citizen to abide by the Constitution, respect its ideals and institutions, the national flag and the national anthem. That's there. Beyond this, we have various criminal laws under IPC providing for punishment for encouraging enmity between different sections. We have the PCRA 1955, section 153B, which declares imputations and assertions which are prejudicial to national integration as punishable offences. We have the UPA of 1967, plus we have RPA, we have the Wildlife Protection Act of 1972, which prohibits trade in rare and endangered species. And if you look at some of the duties, there is one duty which talks about how we have to protect and improve the natural environment, including forests, lakes, rivers and wildlife, and to have compassion for living creatures, Article 51, capital A, clause G. So yes, this is correct. 2 is right. Coming to number 3, individuals are obliged to adhere to them in order to avoid any legal repercussions. See, fundamental duties serve as a warning against anti-national and anti-social activities like, say, burning the national flag, destroying public property, but there are no legal sanctions against their violation. However, it's very important to understand that Parliament is free to enforce them by suitable laws. The Parliament can provide for the imposition of appropriate penalties or punishment for the failure to fulfill any of them. The Parliament can do it. Has it done it so far for duties? No, but it can always do it. However, citizens are not obliged to adhere to them to avoid any legal repercussions. Statement 3 is wrong. 1 and 2 are right. Right answer is B, only 2. How many statements are correct? Question number 2. Consider the following. Inclusion of provisions regarding justiciable and non-justiciable rights. Number 2. Inclusion of separate constitution for each state in India. And number 3, inclusion of several special, temporary, transitory and miscellaneous provisions for certain regions of the country. How many of the above correctly justifies why the Indian Constitution is one of the lengthiest in the world? See, there are primarily 4 factors which have resulted or which have contributed to what we call the elephantine size of our Constitution. One is, of course, the geographical factor, the vastness of the country and its diversity. We have to incorporate things to suit everybody's need. Number 2, the historical factors. The influence comes from the Government of India Act 1935, which itself was a very bulky document. Then single constitution for the center and the states, right? Single constitution. So inclusion of separate constitution is a factually incorrect statement. So 2 is anyway wrong. And the 4th reason is, of course, the dominance of lawyers, legal luminaries in the Constituent Assembly. Hence, the language is slightly more complicated than the normal language that we speak. Yes, we have lot of inclusions, various provisions are there, making it larger in size. Then we have lot of special, transitory, temporary provisions, which again increase or enhance the size. 1 and 3 are right. But 2 is wrong, because we actually have one common constitution, unlike, say, in a country like USA, where the center has a different constitution and every state has its own constitution along with the federal constitution. So 2 statements are right, only 2. B, the right answer. Moving on to question number 3. Consider the following. right against handcuffing, right against delayed execution, right to form cooperative societies, right to the road in hilly areas, right against bar fetters, right to speedy trial. How many of the above rights come under Article 21 of the Indian Constitution? So, right against handcuffing, yes, of course. Sunil Batra, 1978, a very, very famous case upholding the basic dignity of individuals. Right against delayed execution, yes. This was a case in versus the state of Tamil Nadu, TV Vatheeswaran case of 1983, where the court said that right against delayed execution violates right to life and liberty. That is Article 21. Right to form cooperative societies, no. Why? Because this is a part of which article? Article 19, which was added later on through the 97th Amendment Act of the year 2011. So 3 is wrong. Right to roads in hilly areas, yes. Umed Ram Sharma, 1986 versus the state of Himachal Pradesh. Correct. You don't have to remember the case names. The content is important. Right against bar fetters, yes. Petition filed in Supreme Court, a writ petition where Supreme Court had to issue orders that everyone in the jail has a right against bar fetters being chained. No, that is not appropriate. And right to speedy trial, of course, the very, very famous, the mother of all PILs, as it is said, the Husainara Khatun case of 1980. So, how many of the above rights come under Article 21? So, 1, 2, 3, 4, 5. Only 5. C is the right answer. Moving on to question number 4. An officer is required to register an FIR whenever a person provides information about a cognizable offense. See, FIR, first information report, is filed at the first instance that the police is informed of a cognizable offense or offense for which one can be arrested without a warrant, such as say murder, kidnapping, rapes. And according to section 154 subsection 3 of CRPC, section subsection not important. If any person is aggrieved by the refusal of authorities to file FIR, they can send the complaint to the SP, who will either investigate himself or direct it to their subordinates. Statement 1, absolutely correct. Number 2, the complainant has the legal right to receive a free copy of the FIR. Yes, of course, an FIR document that has been prepared by the police after verifying the facts of the complaint may contain details of the crime and, of course, the alleged criminal. Again, according to the same section 154, a copy of the FIR as recorded under subsection 1 has to be free of cost, be provided to the informant. Statement 2 is also correct. Number 3, while the term charge sheet is defined under section 173, the FIR is not defined in either IPC or CRPC. Yes, the term charge sheet has been clearly expressly defined under section 173, but the FIR has not been defined anywhere. Instead, it just finds a place mentioned under the police regulations rules that are there vis-a-vis section 154, which deal with information in cognizable cases. That's it. No definition of what is FIR. So 3 is also correct. All 3 are correct. Right answer is C. The question said how many statements are correct. And the last question for today. The preamble of the Constitution of India does not serve which of the following purposes? Number 1, stating the objectives which the Constitution seeks to establish and promote. And that's the whole purpose of the preamble, right? Indicating the source from which the Constitution derives its authority. It derives authority from the people, as mentioned in the preamble. It does serve that purpose. Aiding the legal interpretation of the Constitution where the language is found to be ambiguous. Yes, of course, it is called the preambular interpretation, where the preamble can be used with other parts of the Constitution to provide a fuller meaning to any provision. So that is one purpose. So D has to be the answer, but let's read D. becoming legally enforceable. Preamble is not legally enforceable. So, when the constitutional provisions do not explicitly provide for certain ideals enshrined in the preamble, no, what has not been provided in the constitution cannot be claimed through the preamble, and vice versa. Meaning, what has been provided in the constitution cannot be prevented by the preamble. So, D is the right answer. It does not serve this particular objective. That's it for today. Let's meet tomorrow. Till then, that's all for me. Jai Hind.